Hi, welcome to our online California divorce course. My name is Kim Morris and I'm going to be your instructor throughout all the lessons within this course. For the first lesson, we're going to discuss the difference between a California default, uncontested, and contested divorce. Please make sure you watch all video lessons throughout this course before reading the content on each web page. Let's get started. So, at the end of this lesson, you should be able to identify which divorce type your case best fits into, such as, are you going to have to file a default divorce? Will you be obtaining an uncontested divorce? Or will your divorce be contested? So, the spouse that files for divorce is referred to as the petitioner, and the spouse that receives notice that a divorce petition has been filed is referred to as the respondent. So, a true default divorce occurs when the respondent chooses not to respond to the divorce petition, which is form FL-120. So the respondent fails or chooses not to file form FL-120 with the court. In a true default case, the respondent gives up his or her right to contest any request the petitioner makes. So the key thing here is the respondent gives up his or her right to request a trial. Meaning, if the petitioner requested for spousal support in their petition for dissolution, the respondent fails to provide a response within the statutory time, the respondent can not later request a trial to litigate issues regarding spousal support if they fail to provide a response. So in essence, the point is moot once it becomes a final judgment. So in a default divorce, if the respondent fails to provide a response within the statutory time, the petitioner can do one or two things. The first thing the petitioner can do is proceed and obtain a default divorce judgment. Or the second thing the petitioner can do is reach an agreement with the respondent, and both parties can enter into a marital settlement agreement, also referred to as an MSA, which details how they're going to divide debts, child custody, spousal support issues. Now, if you do go this route, definitely have it reviewed by independent counsel before having it signed in front of a notary. So next we're going to talk about an uncontested divorce. So an uncontested divorce occurs when the respondent does file FL-120 within the 30 days. So this allows both parties to come to the table, discuss any issues they might have, and reach a resolution. Once they reach that resolution, they could draft a marital settlement agreement and have it incorporated or attached to their final judgment to be submitted to the court for the judge's approval. The final divorce type is what we call a contested divorce. So a contested divorce occurs when both parties cannot agree to one of the following in a divorce. So they're either not agreeing to spousal support, child custody, the division of retirements, assets and debts. Definitely try to resolve any issues you have with your spouse before litigating a matter. Consider mediation at all costs. Litigating is expensive, and oftentimes both parties are never satisfied with the judge's decision. So definitely stay out of court as much as possible. However, if you do see yourself going down that road, then definitely contact us. I'll put you in touch with some lawyers that will be able to handle the case for you. So that's the end of this lesson. Please read the content on this page. If you have any questions, email info@sdsquire.com for more information. Thank you.